Hey everyone, welcome back to the channel. In today's video, we're diving into a pretty unbelievable situation that's been making the rounds online. It involves a woman, let's call her Karen, who has taken her frustration to a whole new level. She's actually threatening to sue the court itself if they move forward with her case without her personal approval. It's one of those moments where you're not sure whether to laugh, be confused, or just sit back with popcorn and watch the whole thing unfold. We'll go through what happened, why she believes she can challenge the legal system this way, and how officials responded to her bold claims. So buckle up, because this conspiracy-like drama gets even stranger the deeper you go. Let's get started.
Township versus Lindsay Dineski.
Yes, ma'am, that's me.
On behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial on this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
I thought you mentioned you were studying to become a lawyer, right? If that's the case, you'd think one of the very first lessons in law school would be understanding the difference between an arraignment and a trial. These two hearings serve completely different purposes. At one of them, you simply enter a plea guilty or not guilty, so the court knows how to proceed. At the other, you present evidence, make arguments, and actually defend your case. Those are not interchangeable steps, and confusing them is a pretty big mistake for someone claiming to know the legal process. So, with that in mind, would you like to take another shot at explaining the difference? Because it might be a good idea to go back and clear that up before making any more big claims about your legal expertise.
Reno this morning.
Yes. I think all charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution.
And honestly, this is probably not the first time the court or its staff have been threatened with a lawsuit by someone acting completely unreasonable. At this point, Karen has reached such an extreme level of stubbornness that it's almost surprising no one has tried to file a claim against Crayola for failing to put a warning may cause severe confusion label on their adult safe art supplies. The situation has gotten so out of hand that it feels like we're watching a real-life parody unfold. Every new outburst, every new threat, every dramatic declaration just adds another layer of chaos to an already unbelievable story. If there were awards for most exaggerated courtroom meltdown, she'd be a top contender without even trying. So buckle up, because if history with people like this tells us anything, we're probably not even close to the last bizarre twist in this saga.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, N-E-R-S-W-I-C-K. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this.
I really don't want to hear any lectures about wasting the court's time from you, Karen. This is especially true considering how many questionable filings you've already submitted, ranging from repeated complaints against your husband to reports aimed at any law enforcement agency that doesn't operate exactly the way you think it should. In the video description, I'll include one of her previously rejected filings. In that document, she claims that several officers from Greene County forced her off the road, only to suddenly switch roles and appear to be assisting her the moment she began recording. The timing she describes couldn't be more convenient. She also included the usual list of arguments, often associated with self-styled sovereign citizens, citing alleged violations of federal rights statutes like 18 U.S.C. Section 241 and 242, along with the assertion that she does not consent to being prosecuted. It's a pattern we've seen from her again and again: dramatic accusations, inconsistent stories, and legal arguments that sound authoritative until you realize they collapse under even the most basic scrutiny. And yet, each time, she delivers them with absolute confidence, as if the sheer force of her insistence will somehow make the courthouse rewrite the rules to match her personal expectations.
And they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court.
I honestly didn't think she'd ever stop talking. And believe me, Karen, patience only stretches so far. But even with all that, I'm not buying the version of events where you claim the police arrested you simply because you asked them for something. That explanation feels a little too polished, a little too convenient, and definitely not the whole story. Every time we look into one of these situations, there's always more going on beneath the surface. Officers don't just appear out of nowhere and make an arrest for no reason, especially not over a simple request. Yet somehow, in your retelling, every detail that might explain what really happened mysteriously disappears. It's always everyone else who's wrong, everyone else who's targeting you, and everyone else who just doesn't understand how the world is supposed to work according to your personal rulebook. But when we compare your version of events with official statements, past filings, and your own history of dramatic confrontations, the pattern becomes pretty hard to ignore. It's the same cycle every time. A situation escalates. You insist you were perfectly calm and innocent. And then you blame law enforcement for reacting to circumstances that you leave out of your story entirely. So no, Karen, I'm not convinced. And the more you talk, the less your explanation holds to.
Karen Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the first.
Yes, but I could ask for it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking.
Weird Sway went through the full legal process to adopt that child, which is entirely separate from anything involving you. Because of that, you don't have automatic parental rights to someone else's biological child. At most, the court can choose to grant visitation, but only if it determines that doing so genuinely supports the child's well-being. But considering your ongoing behavior, your constant claims that everyone is part of some grand plot against you simply because outcomes don't match your expectations, difficult to imagine any court viewing that as a stable environment. Judges look for consistency, responsibility, and the ability to prioritize the child's needs above personal conflict. Nothing about your actions so far points in that direction. If anything, your repeated accusations, dramatic filings, and non-stop suspicion toward anyone who disagrees with you only highlight why the court may hesitate to place additional responsibility in your hands. Decisions in family cases are always centered on what benefits the child, not what satisfies an adult's sense of personal entitlement.
Anna Reno, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Danuski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Danuski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Danuski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
I'm beginning to see a very clear pattern with her. Every time something goes wrong, she redirects the blame toward someone else. In her version of events, she's always the one who swoops in to save the child from everyone around her, even though none of the facts support that heroic narrative. She talks as though the child's biological family failed her, and she alone stepped in as the fixer who set everything right. But what she never addresses is her own inconsistency. She paints herself as someone who saw serious problems in the past. Yet she continued making choices that didn't line up with the story she tells now, instead of acknowledging her role. In any of it, she doubles down and insists that everyone else is responsible for the situation she's in. And now she's even claiming that the child is suffering emotionally simply because they haven't been in contact with her for 2 months. But honestly, if anything, this brief period of calm has probably been the most peaceful stretch that child has experienced in a long while. Sometimes distance isn't harmful, it's stabilizing. Yet in her mind, any time she isn't at the center of the situation, it automatically becomes a crisis. She can't imagine that the world doesn't revolve around her presence, which is exactly why these dramatic claims keep spiraling. And
Actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her, and I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and neglect.
it's called discovery. And if you truly are attending that very legitimate law school you keep mentioning, I'm sure they'll eventually cover it. Discovery is one of the most basic parts of the legal process, one of those things every first-year student learns before they even step into a courtroom. So maybe once you get past the imaginary advanced curriculum you keep bragging about, you'll finally reach the chapter that explains how evidence is actually exchanged in real cases. Clip 8. You have to follow a court order. There's really no getting around it. If you don't, you could be held in contempt, have your bond revoked, and suddenly find yourself attending every future law class at the county jail's very own free legal library. Trust me, that's not exactly the classroom experience most people sign up for. Courts don't take disobedience lightly, and the consequences are very real. So it's always smarter to stick to the rules than test them.
He said he was suicidal and then kidnapped our child, and then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So well,
that's what I'm asking for the agreement due to the fact I was not given any evidence.
I don't think the court puts as much weight on your sense of entitlement as you might think. All right, everyone, that wraps up today's video. She has another hearing coming up in just a few days. And you can bet I'll be back to break down all the next developments for you. It promises to be just as wild as this one. A big thank you to Factor for sponsoring this video. Make sure to check out the link in the description if you want to try their service for yourself. If you enjoyed the video, go ahead and leave a like. If it wasn't your thing, leave a dislike but either way, don't forget to drop a comment below. And be sure to subscribe with notifications turned on so you never miss any of my future content. I'm Team Skeptic, and I'll see you next time.
A court to try to kidnap the biological children from me, and the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they used to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
and I would like to know why I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal